And the way that this is a preferred structure is to actually divide the deal papering, if you want to put it that way, up into sort of three levels. One, first of all, is a master agreement between the two parties, the supplier and the customer. Second one are schedules, which obviously get attached to the master agreement. And third one being statements of work. And the way I like to think about this is that it actually goes on a continuum from law over to business. So in other words, when we have the master agreement, you're going to talk about a lot of sort of what I call the legal stuff. So it sets out the legal agreement between the parties in terms of how the deal is going to operate at a high level. When you get into schedules, you actually have much more of a mixed sort of bag where it's there's legal stuff obviously in there, but it also starts getting much more into the business in terms of what you're actually going to do. What does the customer want? How is the supplier going to do it? And then the statements of work largely end up being what I would call almost the business or requirements, in that you shall produce a module that will allow the customer or the client to input this information. It will go into a database with this sort of thing where it can be saved and sorted. And that's where the actual requirements come in. And so by layering like this, you're able to actually, I think, focus fairly well in terms of what it is the different parts of the deal or the different parts of the documentation are supposed to be doing. So the first one is the master agreement. So I can say this one sets out the terms governing the legal rights, obligations of the parties. Very important ones, obviously, first of all, suppliers' responsibilities for services deliverables. It's pretty key since that's what you're paying for if you're the customer. Payment obligations, which is always very important to the supplier. Intellectual property rights, which I'll have a bit to speak about later, but this can actually be a very difficult area, both in general, but also because I sometimes find the suppliers and customers have very different ideas about what sort of, what the business arrangement is essentially between them here. Something which has already been talked about, Brad talked about, confidentiality, privacy, and security. Especially in the software area, this is increasingly important as compared to 10 years ago or so. Representations and warranties, basically the representations made by the parties in terms of, and by the way, just let me ask a question, how many people are lawyers and how many people are sort of software developer people? So is anyone here who's like purely a software developer and doesn't really have much of a legal background? So do I need to explain sort of what all these terms mean, like representations and warranties, or?
I'm not a student, so I've got, like, I'm working on it.
Okay, that's fine. Yeah, because I'm just sort of flying through these, and I mean, stop me if you have any questions about the specific ones.
And we'll go into detail.
Yeah, we'll go into detail on each one. Termination, transition, that can obviously be very important. As Brad said in his last talk, we do increasingly see shorter term deals. Something which is an interesting question here is there's the traditional idea of a software deal as being, I get my supplier to provide me a piece of software, they provide it to me, I'm happy, we shake hands, I go off and implement it, and I never have to talk to the supplier again. It doesn't always happen that way. Sometimes there are cases where there's an ongoing, I put the thing into production, it's out in the world, in the wild, but I want the supplier to continue to update it over time. And sometimes actually if it's not merely a purely software, sometimes the software is actually attached to hardware as well. So in other words, the supplier isn't just providing a piece of software, sometimes they're actually running equipment or doing things for you. Something which begins to do here is very much this can start to merge into almost being like an outsourcing agreement. So you have to be careful of that sort of thing. And term is one place you can talk about it, but this does come into, when does the relationship end between the parties, or does it? Indemnities is basically one party indemnifying the other in case something goes wrong. Limits of liability is also a very, very key issue. Suppliers, generally speaking, want to limit it to whatever you're paying under the contract. Of course, customers don't want that. Insurance is also an increasingly important thing. Audit rights and governing law. Now, if we go to the next page, you can see here this is, oops, that's it. Okay. Yeah, so this is where we start to get into sort of the mixed business / law procedures, especially, yeah, sure. Sure. Yeah.
Interesting discussion. Yesterday's presentation, morning reaction presentation, by intellectual property lawyers. I think it was commercial lawyers. The clauses that we're always concerned about, we always kind of, I find that in my case, you're always taking a second look at in every commercial contract, software development being a perfect example of intellectual property rights. Definition of trade secrets are really important. The whole idea of confidential information didn't even show up on the list yesterday as an IP right, but yet I think as commercial lawyers, we look at confidential information. We say things like customer list and supplier list are really important. Limitation liability and disclaimer clause are debate on our very existence. We negotiate them over and over and over again, and they really haven't. We have got like forms that we can really rely on and say, this is it, no more negotiation. And I think this is software development agreements, outsourcing agreements, all sorts of agreements as commercial lawyers that do IT-related contracts. We never find the consistency from one contract to another, unless we're acting for a particular supplier or provider or developer. And so what are the different costs on that?
I'm sort of anticipating where we're going to go about 4 or 5 slides, but that is something I've noticed in a number of software development agreements that I've looked at subsequently. And often what I'm doing is I'm actually looking at financing or takeover deals, or somebody comes along and wants to buy startup company A. And so as the lawyer for startup company A, I go and look at the software development agreements where their software is developed by whomever it is over there, and I look and see what is actually promised under those agreements. Do you actually have the rights that you want to then turn around and transfer to the company? And there is a lot of issues actually about those in terms of the intellectual property itself, or whether or not it's properly transferred or not, or what the license is, even sometimes just in how it's conceptualized. I don't particularly have a problem with defining confidential information trade secrets as a form of intellectual property. But having said that, I mean, quite often that's the most important form of intellectual property, whether you want to call it that or not. No, it's important to have that in agreements. Something which I think that software development agreements don't always handle very well is patents. Patents, specifically. Copyright is obviously the critical IP for software development agreements. It's basically that's the actual right to copy the code, if you want to put it that way. And so, in most agreements I've seen at least have that in mind, although sometimes, I've seen ones where they say, I hereby assign you all rights to the software, period. I'm like, well, what does that mean? Is the copyright assigned there? What is, so that confuses me sometimes. Patents sometimes do not get handled properly, and it's because they do need to get treated differently than copyright. And especially if your software development agreement has an idea that you're going to assign the intellectual property from the creator, which is the supplier, over to the customer, that pretty much requires you to do, and if you're going to do an assignment, do a real good assignment. Don't just do sort of a wave my hand, I hereby assign everything and never mention it in the agreement. Because if you look at a patent assignment that somebody drafts up as a standalone patent assignment, it could be like 5 pages long, 6 pages long. I don't know if it needs to be 6 pages long, but there's a lot of stuff in there. And software development agreements often purport to just assign, but they never get into any of the details about what's going on. And so, no, I think that's a good point.
I think on the limited liability issue, and I agree, it's an issue in every contract, and there's really no consistency. I was looking recently at a template that a client had developed, and it's really a form, it's a detailed guide plus a form to be filled out for larger projects. And it's basically setting the risk profile for the project. And that is the basis for determining what the limits of liability should be. When I went through the list, every item I identified as kind of high risk for the particular project I was working on, right? But having done that, if I do that with the business people, I still am not sure quite at the end of the process, precisely what the limits of liability should be, because you can't set, a $100 million limit of liability for $1 million project, right? And then you have to, and in many cases, the value of the contract is kind of the critical factor to determine limits of liability. And then, of course, you get into the discussion about exclusions for claims relating to privacy and security, which is an extremely current issue, I guess, or a very difficult issue, both for vendors and customers these days, more so than ever in view of what's happening with Target and everyone else, right? So, but it's it just means that we're going to be around for a while, I think. Our services will be required.
Yes, they will be.
So,
Oh, that's next page, I guess.
next page. I'm not pressing the right place. Let's try again. Stop searching. Okay, let me try. No. Maybe you would imagine. Let me try this right.
Not sure where we're aiming at here.
Oh, there you go.
Oh, what? Okay, good. You got it. All right, excellent. So, sorry, as I was saying, now we're into this the section talk about schedules. This is where you start beginning to see more of a mix between what you might call the legal governance framework and the sort of the business requirements. And especially here we see the governance framework, change management, dispute resolution. This is all to do with basically how the project is going to be guided from a governance point of view, who's going to be in charge, who's going to say what's going to happen. When, say, the supplier and the customer have an issue, how are they going to decide whether to go, say, down route A or route B? And quite often these things can be very, very low-level disagreements where, a customer wants plan A, supplier wants plan B, but these are the level of the people who are doing coding. And sometimes, so something which has to be thought of here is in terms of being able to efficiently move it up the chain in order to get an answer quickly enough. Problem incident management, this is all sort of around that area. This is what they're talking about. I like to think of it as dispute resolution, but other people think of it in different paradigms. And then if we go to the next page, there we go. This is where we actually get the statements of work, also called service level agreements. And here is really where the customer and supplier have to sit down and do a lot of work in terms of saying what they're going to do. Because, although it somehow seems a bit foreign to the agile computing paradigm, I think the more detail you put in here, the better the chances are there two parties are going to have a happy relationship with each other. Because going in, hopefully they have some idea of what they're going to be up to, what they're going to want to deliver that will make the customer happy. So here's a description of specific products, services, specs, requirements. Start date and term, that's an important thing because there's especially in today's world where the idea of software is it's supposed to be going faster and faster and faster, get those expectations out ahead of time. Key personnel and subcontractors to be provided. It depends often on how the relationship between the customer and supplier, but sometimes the customer actually is going to supplier X software developer because you have worked in this area and I liked what you're doing, so I want you to do it, you or your team or something like that. And so they therefore want the team there as opposed to subcontracting out to whomever. Payment calculation, prices of payment are very important, especially if the more you get into sort of an agile computing methodology. Fraser will talk about that more later. Milestones, triggering payment obligations, obviously. Acceptance, trust criteria, and testing procedures, these can be very important. Especially one thing which I have some experience in is doing software development for software that's supposed to interact with government agencies. Oops. And so one thing that can happen, which is a bit odd, is that sometimes you actually get to a sort of almost like a three-way deal between here's your customer, here's your supplier, and here's the government agency who the software is supposed to comply with or satisfy their requirements. So that's something to think about importantly is the acceptance test criteria. And I'm thinking from the point of view of the supplier. Is the test criteria, what is it? Where does it come from? Is it from a standard agency? Is it a third party providing the testing criteria that you actually have to meet? Because you can actually get yourself in trouble in that you sort of promise I'm going to meet testing criteria, but then the testing criteria is being set by the government. It changes all the time. You can never meet it, or they're never happy with it. You can spend an awful lot of time on that.